Hey everyone, and welcome back for another deep dive. Today we're going to be talking about something that can get really messy. Real estate partition.
Yeah.
It's basically what happens when co-owners of a property, can't agree on what to do with it.
Exactly.
We're talking, family inheritances or business partnerships that have gone sour. You name it.
Right.
And trust me, it's rarely a simple, let's just split it down the middle kind of situation.
That's right. Partition actions, they can get really complicated quickly, especially here in California.
Oh, yeah.
And that's where understanding the law and having a solid strategy becomes absolutely crucial.
Okay, so before we get into all the details, let's just define, what a partition action is.
Okay.
Imagine you and your siblings, you inherit your childhood home.
Right.
Some of you want to sell it, others want to keep it in the family, and you just can't seem to agree.
Right.
That's where a partition action might come in.
Yeah.
It's basically asking the court to step in and make a decision about the property's fate.
Exactly. It's a legal process that's rooted in the idea that every property owner has the right to control their assets.
Okay.
So when co-owners can't agree, the court steps in to ensure fairness and to help everyone realize the value of their share.
Now, I bet there are different ways a court can divide a property.
Yeah.
It's not always about literally cutting a house in half, right?
Right. You're right. There are actually three main types of partition actions here in California.
Okay.
The first, and often the most desirable, is partition in kind.
Okay.
And this is where the property is physically divided among the co-owners.
Gotcha.
Think of a large plot of land being split up into separate parcels.
Okay. That makes sense for land. But what about a single-family home?
Yeah.
I doubt anyone wants half a kitchen.
Yeah, exactly. Partition in kind works best for large properties that can be easily divided.
Right.
For situations where a physical division isn't really practical, we have partition by sale.
Okay.
In this case, the entire property is sold. And then the proceeds are divided among the owners according to their ownership shares.
So everyone gets their share of the cash, but they lose the property itself.
Exactly.
I imagine that can be a tough pill to swallow.
Yeah.
Especially if there are emotional attachments involved.
Absolutely. And that's why courts will often consider the emotional impact, especially in cases involving families and inherited properties.
Makes sense.
Now, the third option is called partition by appraisal.
Okay.
This one's an interesting one here. One co-owner buys out the others based on the fair market value.
All right.
And that's determined by an appraisal.
So it's like a compromise.
Yeah.
Where one owner gets to keep the property, but they have to pay the others their fair share.
Exactly.
I'm guessing this requires some serious financial resources.
You hit the nail on the head.
Yeah.
A buyout can be a great solution if one owner is particularly attached to the property.
Right.
But they need to have the funds to make it work.
Okay, so we've got these three options: partition in kind, partition by sale, and partition by appraisal.
Right.
But how does the court decide which route to take?
That's a great question.
Yeah, what factors influence that decision?
Well, courts consider a whole range of factors, and it's not always a straightforward decision.
Yeah.
One of the most important factors is the nature of the property itself.
Okay.
How divisible is it? What's its best use? Is it a sprawling ranch that can easily be split, or a condo unit where a physical division is just impossible?
So the property itself kind of dictates what's even possible in terms of division.
Exactly.
But what about the wishes of the owners?
Yeah.
Do those matter?
Absolutely. Courts take the co-owner's desires into account.
Okay.
Do they have any common ground? Is anyone adamantly opposed to selling?
Right.
These factors play a role, although it's important to remember that the court's ultimate goal is to find a solution that's fair and equitable for all parties involved.
Oh, yeah.
Even if it means overruling someone's preference.
That makes sense. It's not just about granting someone's wish. It's about finding a solution that works legally and practically.
Right.
But I'm guessing there's more to it than just the property and the owner's wishes, right?
Yeah.
What about the financial side of things?
You're absolutely right. Financial considerations are crucial.
Okay.
Can any of the co-owners afford to buy out the others? What are the tax implications of each option? These are all things that the court will examine very carefully.
Wow, so it's like a giant puzzle where the court has to consider all these pieces, the property, the people, the money, to come up with the best solution.
Oh, yeah.
Makes sense.
And that's why having an experienced attorney by your side is so important.
Oh, yeah, for sure.
They can help you navigate this complex process, understand your rights, and present your case in the most favorable light.
So it sounds like a skilled attorney can be the difference between a smooth process
Absolutely.
and a huge, drawn-out legal battle.
Definitely.
But speaking of drawn out, I'm curious about the timeline.
Okay.
If we find ourselves in a partition situation, how long can we expect it to take?
Right.
Are we talking weeks, months, or even years?
Well, buckle up, because in California, a typical partition action can take anywhere from 6 months to 2 years.
2 years. That's a long time to have a property hanging in limbo.
It can be, and that's why it's so important to understand the factors that can influence the timeline.
Okay.
One of the biggest factors is the level of cooperation between the parties involved.
Right.
If everyone's on the same page and willing to compromise, things tend to move much faster.
Yeah.
But if you've got co-owners who are constantly butting heads and digging in their heels,
Oh.
we'll get ready for a longer ride.
So the more people fight, the longer it takes.
Pretty much.
That makes sense.
Yeah.
But is there anything else that can affect the timeline besides how well the co-owners get along?
Yeah.
What about the property itself? Does that matter?
Absolutely. The complexity of the property can have a huge impact.
Okay.
A simple single-family home is usually pretty straightforward, but a large parcel of land or a commercial property might require extensive appraisal surveys or even environmental assessments,
Oh, wow.
all of which can add time to the process.
So it's not just about the people, but also about the property having its own set of complexities.
Exactly, and we can't forget about the court's schedule.
Right.
Some counties have much more crowded dockets than others, which can lead to delays.
I see.
And of course, the type of partition pursued also plays a role.
Okay.
Partition by sale can be much quicker if the market is hot, while partition in kind might require surveys and physical division, which naturally takes longer.
It seems like there's a whole web of factors that can speed things up or slow them down.
Absolutely.
So before we dive into those factors, let's hear from our sponsor.
Sounds good. Welcome back. So before we jump into the, potential expenses of a partition action, I want to emphasize that it's always worth exploring those, amicable solutions first.
Yeah, I agree. It seems like going to court should really be like the last resort. Especially when we're talking about, family or close business partners.
Right.
So what are some steps we can take to try and resolve things peacefully?
Yeah.
Before lawyers and judges get involved?
Well, the first step is really simple, but it's crucial.
Yeah.
Open communication.
Yeah.
Sit down with the other co-owners, express your concerns, and most importantly, listen to their perspectives.
Right.
Try to, really understand where they're coming from, what their goals are.
Yeah.
You might be surprised at what a little understanding can do to kind of diffuse a tense situation.
It's like any disagreement, really. You need to just talk it out and, try to find some common ground.
Exactly.
But what if talking just doesn't get us anywhere?
Yeah.
What if we're dealing with someone who's just completely unreasonable or refuses to budge?
Well, if direct negotiations hit a wall, mediation can be a really valuable tool.
Okay.
It involves bringing in a neutral third party, a mediator,
right,
and they help facilitate a conversation between the co-owners. The mediator doesn't actually make any decisions, but they act as a guide, helping everyone, stay focused, encouraging compromise, and exploring potential solutions that everyone can live with.
So it's like having a referee to make sure things stay fair and productive.
Exactly. Mediation can be incredibly effective, especially when emotions are running high.
Right.
It creates this, safe and structured environment for everyone to express their viewpoints.
Yeah.
And it often leads to really creative solutions that wouldn't have emerged through direct negotiations.
That sounds promising.
Yeah.
But even if we're trying to resolve things amicably, I imagine it's still important to be prepared.
Yeah.
Just in case.
Right. Absolutely.
So what are some things we can do to, strengthen our position and protect our interests?
One of the most important things you can do is to gather and organize all the relevant documentation.
Okay.
This includes things like, the property deed, any ownership agreements, financial records showing your contributions to the property.
Okay.
Things like mortgage payments, property taxes, repairs, improvements.
Yeah.
Anything that demonstrates your commitment
Yeah.
and your ownership stake.
So it's like building a case, even if we're hoping to avoid going to court.
Exactly.
We need to be able to prove our ownership and demonstrate, our commitment to the property.
Right. And this documentation is crucial because it can really help support your arguments and strengthen your legal standing, whether you're negotiating directly with the other co-owners, going through mediation, or ultimately end up in court.
That makes sense. Preparation is key.
Yeah.
Now, you mentioned financial considerations earlier. And I know this is the part no one really likes to talk about.
Yeah.
But let's be real, these legal proceedings don't come cheap, do they?
They don't, unfortunately.
So what kind of costs are we looking at if we do end up, going down that partition route?
Well, the most significant expense is usually attorney fees. In Southern California, many attorneys charge by the hour.
Right.
And rates can range from $250 to over $500 per hour.
Wow.
Depending on their experience and location.
Yeah, that can add up quickly.
It definitely can. And you'll likely need to pay an upfront retainer,
right.
which could be several $1,000s.
Wow.
Now, some attorneys might work on a contingency basis, meaning they take a percentage of the property's value or sale proceeds if they win your case.
Right.
But that's less common in partition actions.
So finding an attorney who's a good fit for your situation and, your budget is essential.
Absolutely.
But attorney fees aren't the only expense, right?
Right. On top of attorney fees, you'll have court costs.
Okay.
Which can include filing fees for serving legal documents to the other parties.
Right.
And fees for any motions filed with the court.
Gotcha.
If the court appoints a partition referee to oversee certain aspects of the case,
right,
their services will also come with a fee.
So it's a series of expenses that can really add up.
It is.
I'm starting to see why amicable resolution is so appealing.
It definitely is. And remember, while it might seem tempting to go with the, cheapest legal option, an experienced attorney who specializes in partition actions could actually save you money in the long run by handling your case efficiently and effectively.
It's like that old saying, sometimes you have to spend money to make money.
Exactly.
But even with a great attorney, this whole partition thing sounds pretty daunting.
Yeah.
Is there anything else we can do to, increase our chances of a favorable outcome?
Absolutely. One strategic consideration is whether a buyout might be a viable option for you. Okay. If you're particularly attached to the property and have the financial means, buying out the other co-owners could be a way to resolve the situation on your terms and gain full control.
That sounds like a win-win.
It can be.
The other co-owners get their share of the value and you get to keep the property.
Exactly.
But I imagine figuring out a fair price could be tricky.
You're right. That's why a fair and accurate appraisal of the property is absolutely crucial in these situations.
Okay.
The appraisal will determine the fair market value,
right,
which forms the basis for the buyout price.
So even if a buyout is on the table, we still need to be prepared to negotiate.
Yeah.
Are there any other negotiation tactics or strategies that can help us achieve, a favorable outcome?
Absolutely. One thing to keep in mind is California's relatively new partition law, which was updated in 2022.
Oh, wow.
This law was specifically designed to make the partition process fairer, especially in cases involving inherited property.
Oh, that's interesting. Tell me more about that. What kind of changes did this new law bring about?
Well, one of the key changes is the requirement for more comprehensive notice to all parties involved in the partition action. This ensures that everyone is informed and has a chance to participate in the proceedings.
That makes sense. No one wants to be blindsided by legal action. Especially when it involves something as important as their home or family property.
Right.
What other changes did this new law bring about?
Well, another significant change is the focus on giving co-owners a chance to buy each other out before the property is put up for public sale.
Interesting.
This is known as the right of first refusal. And it's designed to help keep properties within families or among the original co-owners if possible.
So instead of the property automatically going up for auction, family members or business partners have a chance to make an offer to keep it within the group.
Exactly.
That sounds like a positive change, especially in situations where there's a strong emotional attachment to the property.
It is. The goal is to give co-owners more control over the outcome and to promote fairness and equity in these often emotionally charged situations.
Right.
Another important aspect of the new law is that it mandates a more thorough and standardized process for appraising the property. This helps ensure a more accurate and objective assessment of its value, which is crucial in determining buyout prices and the division of proceeds in a partition by sale.
So the new law seems to be all about transparency, fairness, and giving co-owners, more options and control.
Exactly.
But even with these changes, partition actions are still complex legal proceedings.
They are.
It sounds like having expert legal guidance is essential throughout that whole process.
Absolutely. And that's why I always recommend consulting with an experienced real estate attorney as early as possible.
Okay.
They can help you understand your rights and obligations, assess the strengths and weaknesses of your case, and develop a strategic plan that aligns with your goals.
So they're like a real estate strategist who can guide us through the legal maze and help us make informed decisions.
Exactly. An attorney can also draft and review any agreements, help you prepare for mediation or negotiation, and represent you in court if litigation becomes unavoidable.
It sounds like having the right attorney in your corner can make a world of difference. Speaking of which, you mentioned earlier that you're based in Southern California.
Yes, I am.
Can you tell us a bit more about your firm and the services you offer?
Sure. I'm an attorney with the Martinez Law Center in Santa Ana, California.
Okay.
We specialize in a variety of legal matters, including real estate partition actions, evictions, unlawful detainers, and other real estate disputes.
Gotcha.
We also handle cases involving auto accidents and premises liability, especially in apartment complexes.
It sounds like you cover a wide range of legal needs.
We do.
Where do you primarily practice?
We serve clients throughout Southern California, including Orange County, Riverside, San Diego, and Los Angeles counties.
That's great to know. And for our listeners who are dealing with property disputes or, any other legal challenges, how can they connect with you?
The best way to reach us is through our website, martinezlawcenter.com.
Okay.
We offer free consultations, so anyone can reach out to discuss their situation and get personalized advice.
Fantastic. Be sure to include that information in the show notes.
Great.
Well, it sounds like we've covered just about everything there is to know about real estate partition in California.
It seems like we have.
From the different types of partition actions.
Yeah.
And the factors that can affect the timeline and costs to the importance of communication negotiation. And strategic legal advice. We've really explored this complex legal process from all angles.
We have, and I think it's worth reiterating that while partition actions can be challenging, understanding your rights, exploring amicable solutions, and seeking expert legal advice can really empower you to protect your interests and navigate this process effectively.
Well said. And on that note, I think it's time for us to wrap up our deep dive.
Yeah.
It's been a really fascinating conversation.
It had.
We've learned about the different types of partition actions, the factors that can affect the timeline and costs, and the importance of having a solid legal strategy. We also explored, some steps we can take to try and resolve things amicably before going to court. And we learned about the key changes that were brought about by California's updated partition law.
Absolutely. And I think one of the biggest takeaways is that knowledge is power.
Yeah, I agree.
The more you understand about real estate partition, the better equipped you'll be to protect your interests and make informed decisions throughout the process.
I completely agree. And that's what the deep dive is all about. Empowering our listeners with knowledge and insights.
Yes.
So if you're ever facing a property dispute with co-owners, remember, you're not alone. There are resources available to help you understand your rights, explore your options, and navigate this complex process effectively.
Well said. And sometimes a little knowledge and preparation can be the key to resolving these disputes peacefully and preserving those valuable relationships that are often at stake.
That's a great point.
Yeah.
Before we wrap things up, I want to leave our listeners with a final thought. If you found yourself in a property dispute with co-owners, what's the first step you would take? Would you try to talk it out? Would you consult with an attorney? Something to think about.
It is. Every situation is unique.
Yeah.
But taking the time to understand your options and develop a plan can make all the difference.
Couldn't have said it better myself. Well, on that note, I think it's time to wrap up our deep dive into the world of real estate partition.
Okay.
Thanks for joining us, and we'll see you next time on The Deep Dive.
Call now 714-442-9741. Thank you.